Oklahoma, Michigan, and South Carolina joining in the fight against Dodd-Frank and, of course, the Consumer Protection Act. South Carolina Attorney General Alan Wilson says the law empowers government at the expense of taxpayers and the Constitution. He joins us now from Columbia. Sir, thanks for taking the time to be with us. I think people need to understand exactly what you're talking about, that we're giving federal officials who are not elected the ability to basically liquidate companies. That's really at the crux of this for you, isn't it?
Well, absolutely. And if you look at the Constitution, you know, Congress has the power under Article 1, Section 8 to create uniform laws covering the subject matter of bankruptcy. What this effectively does is this negates that. The purpose of any law that Congress passes should be to narrow the field of uncertainty. What this does is this expands the field. States like South Carolina, Michigan, and Oklahoma, and many other states, we invest in these financial institutions. We invest tens of millions of dollars. And when these institutions are liquidated at the whims of unelected federal bureaucrats, that could put states like South Carolina in an untenable position. We could lose our creditor rights. We could lose the ability to contest our case before court.
And really, it's in reading it, it's a little bit bizarre to me, actually, that you get Treasury Secretary, FDIC, ability to come in and say, your company has to be liquidated, and oh, by the way, you only have 24 hours to prove otherwise. So where's the due process? Where's the judicial review?
Well, and again, that is why we're bringing the lawsuit on behalf of the states, because it limits judicial review. It negates Congress's power to regulate bankruptcy laws. It does away with the even playing field. It basically makes us subject to the whims of unelected bureaucrats. And further, you know, the economic policy, when you look at why they created Dodd-Frank, was to try to avoid a 2008 financial crisis from ever happening again. Look at this 2,300-page law. At no point in 2,300 pages does it ever do anything to address the problems inherent in Fannie Mae and Freddie Mac. I found that awfully interesting.
And that, of course, has been a bone of contention with a lot of people when Dodd-Frank first came out. You know, a lot of small businesses also complaining about it because of the undue rules and regulations. It's like Sarbanes-Oxley all over again. But many are also out there saying that it's actually done some good. The Consumer Financial Protection Bureau, for one, has brought some things to light for the little people. Don't you agree?
Well, listen, even a broken clock is right twice a day. I'm not going to say there's no good that can come out of a law like Dodd-Frank, but when you look at it from a big picture, what it basically does is, when you look at the CFPB, and that's why some of the private plaintiffs are concerned, is that it's going to chase capital away from community banks and chase that scarce fungible capital to too big to fail banks on Wall Street. It's going to be very difficult for small community banks to comply with the thousands and thousands of pages of regulation that Dodd-Frank is going to require them. Every dollar that a local bank spends on a compliance officer or a lawyer is at $1 less that they can make loans to small business people or people trying to buy their first home. This is going to crush and hurt small banks if we don't stop it now.
Right, and I think, again, many of the rules that will be implemented through Dodd-Frank will hurt small businesses. What are you hoping to do then with Oklahoma, with Michigan? Get rid of the entire Dodd-Frank bill altogether, or just pieces of it?
Well, the states are challenging Dodd-Frank specifically only to the Orderly Liquidation Authority. That's Title II. There are some private plaintiffs that are partners with us in this that are challenging Title I and Titles 10, which is the Consumer Financial Protection Bureau. We obviously want those portions struck down because we believe that those violate the Constitution. Now, there are parts of the law that I think are bad policy to hurt our economy, but they're not unconstitutional. So, you know, I'm not going to challenge something just because I disagree with it. There has to be a constitutional issue with that specific law.
Yeah, and this certainly has one. South Carolina Attorney General Alan Wilson, thanks for being with us and sharing your thoughts. I worry about the bondholders in a situation like that. If, you know, in 24 hours, you only have 24 hours to liquidate, you're going to lose your money.
Right.